Hello, I'm David DeLugas, the $99 lawyer. This week's question: to mediate or not to mediate? That is the question. So what's the answer? The answer is yes. In almost all circumstances, attempting to mediate your dispute, either before a lawsuit is filed or during the course of the case, is a good idea. Now, first, let's make sure we understand what mediation is. Mediation is not a trial. It's not a hearing. It's not a place where you're going to prove how right you are or have to defend against any accusation or claim by the opposing party. Now, this is true whether your case is a divorce case, custody, a business dispute, a family dispute, a personal injury case. All types of disputes. It can be a dispute with your employer. All types of disputes can be resolved at mediation, which is nothing more than negotiation held with a neutral, often called a neutral, or a mediator, who is there not to be a judge or jury, not to tell you what you have to do or not do, but in order to facilitate some conversation, to get people to understand the realities of their case and what it's going to cost them, how long it's going to take, factors that you may not have considered in evaluating your situation and dispute, but you need to consider, because on balance, perhaps you're going to go to trial and you're not going to get what you think you're going to get. So there's some reality checks, is one way it's put in mediation. Now again, at mediation, the thing that's most important for you to understand is you are in control at all times. You don't have to say anything. You don't have to reveal anything. It is helpful, of course, if you try to put out on the table what's really irritating you, what's bothering you, what it is you want. And in my view, one of the best ways to approach mediation is to write a list before you even go, putting in order of importance what it is you want. What is it you want out of the lawsuit that's already been filed or that you're defending? Or what is it you want in terms of the complaint you made against a company or an individual or somebody who has a beef with you? What is it you want that, if you could get it, would allow you to walk away from this problem or dispute? And as well, what would you want if you could get everything you wanted? Now, if you put it in order from the most important to the least important, at the end of the day, to get an agreement, it is likely you're going to have to give up some of the things towards the bottom, maybe even some of the things in the middle. But if you go into a mediation with the goal of getting the most important things to you, and your opponent is there also prioritizing their needs, the company's needs or the individual's needs, then perhaps an agreement can be reached because you can both get what you want. I often call it sit, talk, win-win, which is a company that I developed for mediation purposes. But here, the important part for you to get is you are in control. If you don't say, yes, I agree, then there is no agreement. And the mediation time that you spent was spent exploring a resolution that, if you reach, again, saves you all the time, energy, money, and hassles of continuing with a problem unresolved, or worse, being involved and immersed in the legal system, costing you time, energy, and money for sure. Now, outcomes of lawsuits are never certain, so don't feel as if going into it you are going to win your case for sure or you're likely to lose for sure. Either way, you need to go into mediation with an open mind and try to get accomplished what you can. Share with the mediator, and keep in mind there are going to be times when you and the mediator, or you, your lawyer, and the mediator will meet privately with the other side, not around, and this is called a caucus, and you get to explore things in private. But the mediator is going to know what you said and what you're thinking and what your position is, and go to the opponent and try to work something out, knowing what each of you wants and needs. That's really where the mediator is helpful. The mediator, without trying to help one side win over the other, is going to try to find what is the middle ground, or where is the middle ground. It may not be in the middle, it might be toward one side or the other, but it'll be based upon what each of you expects to get out of your case and what you must get out of your case in order to reach an agreement. Very important. If you feel unsafe or you're not comfortable being at a mediation, don't go, or arrange to do it remotely by webcam or by telephone. That can be done. If your case involves violence, then you're often going to be excused from having to do it, of course, but you can also do it with a deputy or a sheriff nearby, or even in the room. Now, when you go to mediation, you most often are allowed, of course, to have your attorney with you, but generally not another person, a family member or friend with you unless the other side agrees, having something to do with making sure the decision maker is in the room and making sure that confidentiality is held, because what is said in mediation, if you don't reach an agreement, cannot be used in your court case, and what is said in mediation cannot be used even if there is no court case, because that information is supposed to be kept confidential, and you will be signing an agreement going into the beginning of the mediation that everything is confidential. Now, let's say things work out and you reach an agreement at mediation. Handshake is not good enough. Make sure a detailed agreement is written and signed by everybody present, certainly the principals of the agreement, before leaving the premises. Do not leave without that in hand, because unfortunately too often agreements are reached, and the agreement is that one of the attorneys will go back to their office and prepare the final document, and everybody will sign it later. Except the memorandum that you come up with at the mediation isn't sufficient, doesn't cover all of the terms, doesn't have the language the attorneys have agreed on, and so ultimately all of your time and energies will not benefit you. So don't leave without the agreement being signed. If you don't reach an agreement at mediation, don't feel as if you just wasted a bunch of time. You likely learned a lot more about where you are, where you need to be, and you learned a lot about your opponent's case or their situation. So that'll benefit you going forward. In any event, attempting mediation is almost always a very, very good idea, as it gives you an opportunity to end your dispute with an agreement that includes terms that you really wanted and you needed to see take place. So give that a shot. Now, post your questions on our Facebook page, and I hope if you find an opportunity or a need to consult with me, book a session, and I'd be happy to help. Thanks so much.